Hi, good evening, everyone. Welcome to another edition of our Justice and Pieces guest speaker series. Today, we are joined by Neil Wilson, who is a partner at Stevenson Welton. So, thank you so much, Neil, for taking the time here and joining us. And looking forward to hearing about your practice and how everything has gone. And it's been a long time, I think, since we crossed paths way back at Osgoode there. So, maybe you could tell us a little bit about what got you into law there in the first place, and then what's got you to where you are today.
Sure. Thanks, JP, and thanks for the invitation. And yes, long time no see. What got me into law is it's a terribly boring explanation, but I think it's actually a pretty common explanation, which is I was finishing up a undergrad arts degree and looking at the different options, and law seemed like a pretty good option. I had a friend who was doing an LSAT course and kind of twisted my arm and suggested that was a good idea, and I did it, and it seemed like an interesting option, and that's the path I took. What's kept me here is it was an interesting option. It's a diverse career where you get to do all kinds of different things, learn about different industries, different areas of the law, and so it's been kept me on my toes essentially for my entire practice. Together with working at a firm where I think I have to say my colleagues have also kept me here in the sense of they're good people to work with.
Yeah, so I think it's unique there. I mean, that certainly you've after you finish, you've been pretty much there since, right? How's that been in terms of keeping you? So your colleagues there keeping you there. What's it been like in terms of growing from coming on board there to becoming a partner?
It's been good. I mean, it's people ask me that question, and what changes from being a first year to a second year to an associate to a partner, and it's so gradual. It's not like one day something changes and from one day to the next you're doing something massively different. As a lawyer or as a paralegal, you're developing kind of month after month after month as you do new things, take on different kinds of cases, work with new people. So I really do think it's kind of an organic.
So I think you hit the mute button there, Neil.
Must been the space bar. I'm not sure where I left. I'm gesticulating too much here, but what I was saying, JP, was it's a gradual process. It's a gradual process, like in any career, of continuously learning, of working with different people, working against different people in terms of the lawyers you're working with on the other side of the case, taking on bigger and bigger responsibilities, both in terms of the size of the cases you're taking on, having your own files and more direction over your own files. So it's a gradual process, but it's a constant process. And then at some point you turn around and say, wow, that I just did that. I think if I tried to do that 5 years ago, I would have found it impossible / incredibly stressful. And now I'm doing it, and it seems fun and not stressful. So I think that's the progression that I've seen, at least.
Yeah, so you mentioned it's coming gradually. So what are some of the things that when you look back now and say, well, when I was starting off here, like I wouldn't have thought I could be doing a matter there, a constitutional challenge and all of that. What how does it come piece by piece there gradually over time? And what do you learn and going back and continuing on with building on building, brick by brick, so to speak?
It really is brick by brick. So even when I think back to, to the beginning, even the smallest court appearance now that you would not think is a big deal at all, wouldn't need to spend any time preparing. I would spend hours preparing for it to make sure I'd crossed every T and dotted every I. And after kind of a process of repetition and just knowing what it's going to be like, it takes less and less preparation. And it also, as you progress to bigger and bigger things, gives you the confidence that, there was that case where it was totally new to me and I worked hard and I figured it out. Therefore, because I did it there, I can repeat that process again in a different subject area with a bigger case or a different set of issues, basically.
Yeah, so maybe you can tell us a little bit about your practice. What are the types of things that would come across your way now, and how's everything been going with respect to that?
So we're what people call a litigation boutique. So we're a relatively small firm of 12 lawyers, and we only do litigation. So litigation, we don't do, for example, solicitor work or contract drafting or corporate transactions or that kind of thing. And the way my kind of elevator / cocktail party explanation of it to people is, we do all kinds of litigation, but we don't do any criminal law or any family law. Those are the two big areas we don't do. So what's included in that? It includes things like commercial litigation, so corporate disputes, contract disputes, disputes over money. It includes a fair amount of real estate litigation, as well as we have a personal injury practice and just a general plaintiff side practice. And so it really is that that kind of just traditional barrister mindset of, we only do litigation, we do a number of different areas, but all we do is civil litigation.
And I guess for our students there, in terms of wanting to get into practice and get into litigation, what can you maybe just say from your years of experience there? Some tips there that have got you through. Again, we were talking brick by brick, but looking back now, when you first started, what you wish you knew getting into litigation that you know now?
That's a good question. You can't really mess anything up that badly. I know when you first start, you think, okay, if I don't do a great job on this submission, on this cross-examination, it's going to, or this this piece of writing, etc., it's going to essentially ruin somebody's life or have these disastrous consequences. If you work hard and if you think through what you're doing and give it the full effort and attention it deserves, generally there are very few mistakes that aren't fixable. And I think that with that kind of mindset in mind, that would have been a big stress reliever for me, or and I mean, I'm sure even if you tell people that, they'll still think that mistakes are possible. I think the other thing is just being willing to take on basically whatever's thrown at you. So if an opportunity comes up, or if a lawyer at your firm trusts you with something, there's a very good chance that not a very good chance, you can do it. You can do it properly. You can do a great job with the appropriate guidance or mentorship as needed. So I think just having that confidence to know you can take it on, you can do a great job through hard work and a little bit of creativity.
Now, with litigation, obviously, it doesn't just come like the TV shows, right? That you get the case and then next day you're in court arguing.
Yeah,
so maybe you can walk us. Maybe you can walk us a little bit through there in terms of whether it's a personal injury file, right? Or because there's a number of different stages, and go through kind of what happens when it comes in. You get an intake, and then if it does end up going all the way to trial.
Yeah. So just from beginning to end, I'll summarize it. And what I'm summarizing is really a multi-year process. And it's unfortunately a multi-year process because I wish things went a lot faster in our court system. Unfortunately, they don't always. But in terms of the process, you can basically break it down into a few different phases. And so the first phase, I would say, is kind of the intake and investigation phase. Client comes into your office. Maybe it's a client you've worked with before. Maybe it's a referral or a new client. And you work with the client to work out what their issue is, to gather the relevant documents and information that you need, and proceed to open a file and to essentially become involved in litigation if that's what's required. Once that decision is made, there's what we call the pleadings stage. And pleadings are basically it's essentially the document that starts a lawsuit. So a statement of claim setting out what the allegations the plaintiff is making are, and a statement of defense, which is the same thing, but for a defendant. And so those pleadings are exchanged. And once that is done, normally the next stage is what we call discoveries. And there's discovery both of written or not written, but just a discovery of documents, in the sense of, in Ontario, civil litigation is based on the principle of full disclosure. So all relevant documents that each side has get provided to the other side. So each side essentially has full access to all of the relevant documents assuming something is subject to privilege. And then you move on to oral examinations for discovery, where each side is entitled to ask the other side questions under oath. And the whole goal of that is to enable both sides to understand the other side's case, but also to get admissions that could be helpful at a trial later. And that globally, I just kind of describe as a discovery process. And after that, although it sometimes can happen before discoveries, is in Toronto at least, and in some other places it's mandatory, and in many other places it's common, to at some point have a mediation where everybody gets together with a neutral party, a mediator, who is agreed on by the parties, who helps the parties try to settle the case and to make their own decision about what the end result of the case will be, rather than leave it to a judge. And if that fails, and if a trial is required, then finally we get to a trial, which is what everybody thinks you're jumping to, day 3 after you walk into a lawyer's office, which, as we know, is not the case. And sprinkled anywhere in there can be motions, which is essentially a proceeding within a proceeding to determine one specific point within the entire piece of litigation, including, maybe most importantly, what's called a summary judgment motion, which is where one side says, this case is so obvious that we don't need a full trial. It can be determined based on affidavits and a paper record.
Now, I mean, the big thing over the last couple of years is we've gone from sort of process exactly like that, but now we've moved it, at least part of it, perhaps even all of it now, with respect to being on Zoom like we are here, or Teams, or wherever virtually. What have you noticed in terms of the stuff you were doing in 2019 versus in 2021?
Yeah, it's a great question. Really everything, and I mean almost literally everything for civil litigation, has gone virtual and largely on Zoom, almost exclusively on Zoom. And so that includes out of court examinations for discovery. It also includes trials. So, for example, we did a virtual trial back in October, which was fully virtual. 2 and a little bit weeks. Everybody was either in their office or in their homes, including all the witnesses, the lawyers, etc. Mediations, literally everything by Zoom. And I think there are pros and cons to that. And the pros obviously is, it's not even a pro, but it's just essentially required, because everybody can't go do it in person. But I think there are also some advantages. So it's a cost reducer in the sense of everybody doesn't have to travel to downtown Toronto or downtown wherever you are to get together to participate in a certain stage, which is a big cost savings for parties, and I think a plus for access to justice. And some of the technology is just great. So there's a new program called Case Lines, which the court is using, which is very helpful. I think people are getting more and more comfortable with the technology. In terms of cons, I think I'd still, for some things, rather be in court. And it's just, there are beyond all the technical hiccups, it's sometimes easier to communicate your ideas when you're sitting face to face, or if it's a judge looking up at a judge, kind of trying to communicate your ideas.
What did you find the most challenging there about that virtual trial compared to being in? I mean, is it just, you mentioned technological hiccups, but is there any more there that you felt if it was in person, it would be done a little bit differently or would have gone smoother on your end?
No, I mean, for that particular trial, everybody knew how to use the software properly. And it wasn't, I can imagine other kinds of situations where if there was a witness or if people weren't that comfortable with it, it could be an issue. There were technology hiccups, but you deal with them. So, the internet comes disconnected for one party, fine, let's take a 15-minute break. We'll come back in 15 minutes. It can be dealt with. I think everybody is learning the technology. So if everybody is not 100% up to speed on Case Lines, etc., judges, other lawyers, parties are generally understanding of that. And so, while I do think it's essential that everybody get up to speed, it's not as though, at least at this point, anybody's being penalized for not being up to speed on the technology. And you really do just learn it by doing it. So you just become comfortable with it, just in the same way we've all become so used to and comfortable with Zoom over the last 18 months or almost 2 years now.
And you think, let's say we flash forward, I don't know how long we flash forward every time, just when you think it's so over,
Yeah,
it gets delayed there. But let's say eventually we're in a time where it's not a necessity to do that. We have options. Are there going to be elements there in what's been done that will stay online, like, or I mean, in case lines, even there being an example. But what do you think is here to stay, and what do you think may have to revert, or at least give an option of returning back in person in the courtroom?
So in person, I think trials and big hearings where there's either a lot at stake or it's an important hearing where it would just be beneficial to be in person. I think those will, and I hope those will go back in person, at some point relatively soon. Things like examinations for discovery and mediations, it really depends on the case. So some examinations for discovery, I think, maybe if credibility is a big issue, if there's somebody who's not really comfortable manipulating the software to get to the right document in a document heavy case, et cetera, I think those kind of things may go back in person. But at the same, I think for many discoveries, they won't. It's just too convenient for people to do it from the office. Originally, or not originally, but at the outset of the pandemic, there was this discussion about, credibility, and I really need to see the person face to face. And at least in my opinion, I can see you perfectly having this conversation. You can see somebody maybe even better when you're face to face, looking at them even through the screen. And so I don't think that is going to be a reason to revert completely to how things were before, and I don't think that's going to happen. In terms of mediation, I mean, I do for some things think it's helpful, just as a practical matter, to have everybody together in the same space. And then finally, I think the thing that I just hope 1,000 times over will never go back in person is things like scheduling courts, or to be spoken to courts, or small little attendances where you're actually only on your feet, speaking for 15 seconds or so. I really hope that nothing like that ever goes back in person. And frankly, I hope that things like that go to more of a kind of electronic scheduling or booking or just written format, so that we can do away with those kind of unnecessary attendances.
Yeah, certainly. I mean, I think you could be more efficient, where then a lot of the court time is best used there for, as you mentioned, serious hearings or trials themselves. Then you don't have to have so many people being kind of occupied with setting a simple set dates and appearances that we were doing pre-pandemic. Now, in terms of the whole process there, I would be amiss if I didn't mention there for my paralegal students who are thinking, well, what are the options that are available for us in boutique litigation firms? And I know there's a number of paralegals that work there. So maybe you can tell us a little bit about how they assist in matters for you.
Sure. So at least in our firm, we have 4 paralegals who work in our firm. And in addition to paralegals, we have a number of law clerks and legal assistants. And the paralegals help, at least in our firm, with a range of things. So they will help on larger files in terms of things like preparing briefs, kind of paralegal support work on large files, either in commercial litigation or sometimes in personal injury matters. But there are also matters that some of our paralegals will handle completely on their own, such as, for example, tribunal proceedings, or I think the big one is small claims court proceedings. So I know one of our paralegals in particular, who's been with us many years, has done, this is pre-pandemic, tons and tons and tons of small claims trials. And that is something that is it's just of increasing importance because, as you know, the jurisdictional limit for small claims has now been raised, or was raised a couple of years ago, to $35,000, which means that more and more significant-ish cases are ending up in small claims. And so I think that is a key area where paralegals can help both within firms and essentially within their own firms in helping out with the kind of access to justice issues that the system is facing as a whole. I know there's another issue now, which is that small claims court trials aren't really being scheduled, but hopefully that will be fixed and we'll be back to normal relatively soon.
Yeah, so you brought up access to justice. I know that's something that it's very dear to you. So maybe you can tell us a bit about access to justice and how things have maybe changed and progressed as a result, and your experiences in providing that.
Yeah, I mean, it's at least since I've started, not since I started practicing, since before I started practicing, it's been a problem. It's been a problem in the sense of getting a legal representative, a lawyer, a paralegal, etc., and getting your case dealt with and moved through the system it's too expensive. It's too expensive and it's too slow. And there are 1,001 reasons for that, and there's no one solution to it. Everybody in the system is trying to work towards progress and trying to fix that issue. And one of the solutions that's come about as a result of the pandemic is more use of technology. So more use of technology for, as I've said, scheduling hearings and things like that, but also examinations for discovery, tools that people can use to make litigation less expensive in terms of, and meaning less time consuming, that less lawyer and paralegal time needs to be spent on things. Something like raising the jurisdictional limit of the small claims court makes sense for access to justice as well, because JP, it is, in my opinion, and this is only my opinion, close to impossible to litigate a case over $40,000, $50,000, even $60,000 in superior court in a way that's economical. And so allowing more of those cases to go to small claims, I think, makes sense from an access to justice perspective, because people can still be represented by a lawyer if they wish to still go there, but there will be cases dealt with faster and with less expense, which will also have the effect of freeing up more judicial resources in superior court to handle those cases in a both cost-effective and expeditious way.
Yes, I mean, is there sort of potential then to go, let's say, from $35,000 to $50,000, and that would capture? I mean, what are you seeing maybe in terms of files where they kind of come in at that amount, just under 100,000? I mean, I know you do a lot of serious personal injury ones where the cost there would be potentially in the millions, right? But I mean, how many matters that are going to superior court, even if you're just kind of waiting for your matter, that you're seeing that are potentially 100,000 or so or less?
Yeah, so there's kind of three general stages. So there's small claims, which goes up to 35,000. There's something called simplified procedure, which is superior court, but it's between 35,000 and now 200,000, recently increased from 100,000. And that supposedly is there's less procedure involved. The case moves much faster. I actually, that's not really my experience. I don't think those cases do move much faster. But in terms of those cases that are at the 50, 60, under $100,000 level, my personal opinion is I think raising the small claims limit to $50,000 is a good idea, because it would allow people with claims that are, it's not a small amount of money. Like $50,000 is not a small amount of money for most people in this province. And to not be able to have an expeditious way to deal with it is a problem. And so I think creating that opportunity through small claims court makes sense. And it also gives even cases that are higher than that amount, because as you know, you can if you have for example, a contract case and a party is owed $60,000, you can go to small claim, or it's wrong example. If it's worth $40,000, you can go to small claims court over that dispute, as long as you limit your claim to $35,000, which I can tell you would make most sense in 99% of cases. So it also captures those cases where people can just make a decision to forego whatever the amount is above the small claims limit to have their case heard there. The problem now is that they're not scheduling trials in small claims, which is a whole other discussion. But it is a change that I think makes sense.
Now, I guess pre-pandemic, there maybe can give us an idea of how long it takes, let's say, for a matter. You were mentioning, when you were giving us the overview there, it's the years, but I mean, what did you find in terms of when you get to trial? And I mean, even if they're on the list, you're not necessarily going to be called at that time. You might have to wait, I think, like November and June, or I think it was like that when I remember. I don't know if it's still the same, but what's the sort of the delay in terms of getting from, let's say, I mean, even there's initially potentially a 2-year period between the incident and when the claim is filed, right? So what are we looking at in terms of timelines from in years?
So it depends on partly how fast the lawyers and the parties move the case. So before you can go and get a trial date from a court in Superior Court, you have to do what is called filing a trial record, which is just a complicated way of saying, basically telling the court, I've done everything I need to do in terms of discoveries. I've had my mediation and everything else. I'm ready for a trial. And so how long that process takes is largely dependent on how hard and fast and the lawyers are moving that file forward, so that one party is ready to schedule it for a trial. Once that's done, how long it takes for a trial depends largely on two things. One is, how long is the trial? So if it's a trial that is under 5 days, at least in Toronto now, you can get reasonably prompt dates, in the sense of, I think within the year, based on my recent experience. If it's a longer trial, so if it's a trial of, say, it's a 2 or 3 week trial, you're looking at a much longer period of time. And the second thing that determines how long you're going to wait is where your claim is. So where you've brought your lawsuit, and there's a big difference in terms of different jurisdictions: Toronto versus Ottawa versus Newmarket. And some jurisdictions have what's called a rolling list or a blitz list, which is what you referred to earlier, which is there's a certain period of time during which the court calls a bunch of cases. And so you don't actually have a fixed specific date for your trial. You just know your trial is going to be called in, for example, the May sittings in Newmarket, or the November sittings in Newmarket. So that's how it works.
I did want to talk about a case that you did a couple of years ago. It just, I usually give this example in class, like, well, there's bona fide occupational requirements, and if, for example, you can't be blind there to be a bus driver. And ironically enough, I should be taking that back the next time I mention it because of this case. So maybe you can tell us a bit about the case and how you were successful there. And I think it's very unique, and I'm sure my students can benefit from listening about it.
Sure. So the case, I think the case you're referring to, it's a case called DiCienzo and Ontario, and the case involved a person who lost vision in one of their eyes and was working as a bus driver at the time. And as a result of losing one eye, so having what we call monocular vision, which is just vision in one eye, as a result of the licensing rules for commercial drivers, she was not able to do her job anymore, was not able to drive a bus, and lost her license. And when you first hear about a case like that, and this was my experience when I was working on the case, when I first told people about the case, the kind of initial first impression, that sounds like it makes perfect sense. But when you dig a little deeper, the evidence doesn't really support that in this sense, which is that a person with one eye or with a vision deficit can adapt and can learn ways and can compensate for their disability and learn to, or essentially can drive safely. And so what we were asking for in that case was, it was a challenge to the rule that was an absolute rule that said you cannot under any circumstances have a license if this is your vision, no matter how good a driver you are. And what we were saying was that the law should say that not that you automatically get a license, but that there should be a process in place to individually assess people to see if they're able to compensate and if they are able to demonstrate that they can drive as safely as a person who meets the vision requirement.
Yeah, and part of that obviously goes through sort of the constitutional analysis, and I believe afterwards they had to make the amendments to that regulation. So I mean, that's something certainly you can take from it and say, well, we were successful in bringing about that, not just for your client, but for anyone that would be in that potential situation.
Yeah, and I mean, I think my view is obviously in a biased way that it was the right result. And I mean, you mentioned bona fide occupational requirement, and that kind of goes to the human rights legislation. But this law, this statute actually had baked right into it. It said this requirement applies despite the human rights code. And so what we had to do was we had to challenge the law under Section 15 of the Charter of Rights and Freedoms, which is part of the Constitution. Which, as you know, you can't legislate out of. And so that was how we pursued it, and we're thankfully ultimately successful.
Now, before we were talking about access to justice, and I know another recent initiative that you were part of there was the on CanLII. They have a new text, their civil procedure and practice in Ontario. So maybe you can tell us a bit about what that, going back and doing something there, and what that brings in terms of access to justice as well.
Yeah, so CanLII, I'm sure most of your students know what CanLII is, but for anyone who doesn't, CanLII is a free website in Canada, not surprisingly, that essentially publishes and has published for, I think, at least the last 20 years, all or makes publicly available essentially all court decisions, both court decisions and tribunal decisions across Canada, and has a search function where you can essentially go through and search for different kinds of cases using keywords. And that was originally what CanLII was known for and still is known for. It's a fantastic resource. What CanLII has increasingly done, and that's the civil practice and procedure in Ontario text that you're talking about, is to collaborate with authors to create resources. Oh, sorry, my screen has gone dark here, JP. Yeah, there we go. To create resources or guides, kind of similar to your traditional textbook, to be made available for free online. And civil practice and procedure in Ontario is exactly that. It's a guide that's similar to the Watson books, the kind of blue book with the rules and all the annotations that many civil litigation lawyers have, but that's available free online and is written in a way that is useful not only to lawyers and paralegals, but also to people who are self-represented. So it's written in a way that's intended to be accessible and easy to understand, and presented in a way where you can look at the overview and understand, but you can also go deeper into the cases. And it's a project it's kind of a collaboration between the University of Windsor and Professor Noel Semple there and CanLII, and different litigators from around the province contribute, not just litigators, people from who with different kinds of experience, litigation and other experience, contributed chapters on each of the rules that are in the rules of civil procedure, which is basically the roadmap for all civil litigators. So different chapters on things, summary judgment or examinations for discovery or pretrials, with different authors contributing different chapters, and all having them kind of intertwined and integrated. So you can click and hyperlink the references to the other chapters if there's something that you want to go look at in another section. I encourage everybody to go take a look at it online. I really do believe it's a fantastic resource.
So how was that in terms of contributing some there? What areas did you talk about there? And in terms of again, access to justice, I mean, are you still seeing in Superior? I mean, I know certainly in small claims court, there's quite a lot, but are there still quite a significant amount of people that are self-represented that don't really know how the process works?
Yeah. So in terms of the parts of the civil procedure text that I did, it was examinations for discovery and pre-trials, which are things that I think are not necessarily intuitive to somebody who hasn't participated in them or been taught about them before. In terms of my line of work, so civil litigation, I don't see a lot of self-represented people. I do have the odd file where there will be a self-represented person on the other side, where I'll do my best to just give them the whatever basic information they need about how to participate in the process. And my judges will generally try to do the same thing, to just make sure that they're understand what the procedure is, understand what is expected of a litigant, etc. I know that family law is an area where it's a big issue. And I think there's also that gap of people who aren't able to pursue claims that are valid, or aren't able to fully defend claims with defenses that are valid because of the cost of litigation. And so I think that's a gap in the system as well, unfortunately.
Now, Neil, one of the things we've talked about with many people in the profession here, especially actually yesterday was Bell's Day there, but dealing with mental health and working in the profession, right? You tend to have really long hours. There's a lot at stake for your clients, and try to find that balance, right, with life and work, and again, with all of the stressors that come with it. Anything that's worked for you that you can share with students or young practitioners, especially obviously trying to move up, right? I mean, I think there's always this belief there, when you're starting off, that, you need to put in those really, really long hours and sacrifice everything in order to become a partner, or to go somewhere else and maybe become a partner in some areas of practice. So maybe you can share anything that's from your experience that's worked for you, and for anyone that's listening.
Yeah, no, for sure. So I mean, I don't want to sugarcoat it, JP. I mean, it is a profession that has its stressful moments. It's a profession that there's hard work involved, and there are expectations, because clients are entrusting lawyers and paralegals with things that are very important to them, and they have an expectation that is fair, that their representatives will work hard for them and respond to them, and understand their issues, etc. That being said, I think it's important to always bear in mind that, or not to kind of take on your clients' problems and stresses as your own. You don't create problems for your clients. So people will come to you with an issue that is not, like I said, hopefully 99% of the time, not an issue that you had any involvement in creating. And so you're part of the solution. Your job is to help find help guide that client and help get them to a solution. But you shouldn't think that you shouldn't take on the stresses of those problems yourself if you can avoid it. I guess the other piece of advice is just to stay connected with your friends and family outside of law. It's so easy just to get caught up in kind of the bubble of law, and you're dealing with other lawyers and judges and friends from law school, and it's just easy to kind of get caught up in that bubble. And I think it's just so helpful to stay connected with your friends outside of law, with your family outside of law. I know when I speak with my friends who are outside of law, they don't it's almost refreshing in the sense of they don't know really that much about what I do, or the different stresses involved, and that can be a de-stressor of itself, because in itself, because you can kind of step out of just the law world and just remember that you have a life that has nothing to do with law out there, with family and friends and interests outside of the law.
Perfect. So Neil, thanks for taking the time here and joining us and sharing from your experiences there in terms of litigation and everything else we've talked about. Again, I know we were looking back there from getting into your first year as an associate all the way up to becoming a partner. But any final words of wisdom for, in particular, the students that are listening in terms of wanting to get into litigation and wanting to get into practice there, or personal injury, even for that matter, or real estate? I don't want to talk much about that area of your practice, but any final words of advice? And thanks again for joining us.
Yeah, thank you, JP. I mean, I think just staying curious and taking all of the opportunities that come at you, and going out and seeking those opportunities to try new areas of law, to work in new areas, to take on whatever comes at you, and to stay interested and engaged as you progress through your career.
Perfect. So again, thanks again. And for everyone, thanks for tuning in. Take care and stay safe. Thanks again, Neil.
Thank you very much, JP. Great speaking with you.